Thank you, Mr. Hibner, and thank you to counsel for joining Judge Bennett, Judge McBrayer, and me in this oral argument, which we are broadcasting by live streaming and which will be available for future viewing on the website of the Administrative Office of the Courts. We will conduct the hearing in the same fashion as if all of us were in the courtroom together. Each side has 15 minutes, and the appellant may reserve up to 5 minutes. And I understand Mr. Preston has already given his request in that regard. Unless there's any announcement or other preliminary matters, we'll ask Mr. Hibner to call the case.
Horizon Trades, Inc. versus Aubrey Givens et al.
All right, the floor is yours.
Thank you, Your Honors, and good afternoon. My name is Klein Preston. I represent the plaintiff appellant in this matter, and this is a single issue matter that arises from the dismissal of a claim for malicious prosecution. And the issue is the second prong of the requirements in a malicious prosecution case are, as we know, and the law is undisputed on most of this case, that the original action has to terminate in the favor of the now plaintiff. And in this matter, the trial court dismissed the case and found specifically that our case, the original case, was not terminated in my client's favor because it was terminated for, and this is where the issue arises, the statute of limitations. And we both agree that that is not a termination in the dismissal of a case if it's based on the statute of limitations. However, this case is distinguishable, and this is where I submit that the trial court erred, and that is, in this case, the order dismissing the original action found three bases for the case to have been dismissed in my client's favor, and two of those three we respectfully submit are terminations in my client's favor. In the order, it says, admittedly, the statute of limitations, but it also in the order says alternatively that the dismissal was because the court found that there was no viable contract, and because the court found that even if there were, that the statute of frauds would be a defense. And so we respectfully submit, because of the way this order is drafted and the trial court's findings in the original action, that it satisfies that second prong of a malicious prosecution case. The two bases that are set forth in that order itself, we respectfully submit do constitute a dismissal in my client's favor, because if the original prong or the original basis, which was the statute of limitations, is not there, then we have these other two findings, and these are essentially findings of fact. And so respectfully, I think the interpretation, although partly correct at the trial court, if you're talking simply about a dismissal based on the statute of limitations and that not being on the merits, that is true, and we don't argue that. But within the same dismissal, there were these specific findings that are findings that are in my client's favor and would support and did support, we submit, the argument that that original claim was terminated in my client's favor. And so I think the trial court erred, and admittedly, I can't and have not found a case that is on point specifically with this fact scenario where you actually have multiple bases for the dismissal, two of which in our view are proof that it was in our client's favor on the merits, and one being a procedural or technical defense basis. And so when you read it in whole, we respectfully submit that the trial court erred in that finding, because even the findings of fact, both of which are established by the trial court, are proof of the termination in our favor, my client's favor. And so if you really drill down and look at what is the reason for this second prong in a malicious prosecution case, it's because the issue in a malicious prosecution case goes back to probable cause. And if you're going to dismiss a case based on a procedural matter, that doesn't address a probable cause issue. All that does is say, well, you lose the case, but it doesn't really get to that issue of probable cause. When you talk about these two defenses and two bases by which Judge Gayden ruled originally in this case, they do satisfy that issue. Now, admittedly, there's another step, and that would be an inquiry at another point, should your honors remand this case, and that is as to probable cause at the time of filing and as the case progressed. However, we're not at that point. This was just a Rule 12 motion to dismiss. Mr. Glassman, was successful on it, and I understand his argument. We respectfully submit that based on this, the trial court erred in making that finding, because this is admittedly a unique situation where you have actually all things are in the final order. You do have a finding that it was based on statute of limitations that Judge Gayden found, but at the same time, we also have termination bases that were support that second prong of the malicious prosecution case. And so it's our position that the trial court erred on that, and we would ask that the court reverse trial court, remand it, and in doing so as well, make a finding that based on that reversal, that the award of attorney's fees under 20-12-119 would be and should be reversed as well.
Thank you, Mr. Preston, and we'll hear from you again on rebuttal. Mr. Glassman, the floor is yours.
Thank you, Your Honor. Let me first say, I think there's more that's agreed to than is not agreed to. And it's agreed that this is a malicious prosecution case. It is agreed that this is a de novo hearing without a presumption of correctness, since it is a question of law. It is agreed that TCA 20-12-119 paren C close paren is applicable. There was no objection to my affidavit of fees and expenses that exceeded $10,000, and Judge Aubrey made the award of $10,000. There has been no execution or attempt to collect because all appeals have not been expired under 20-12-119. What's not agreed is, was Judge Gayden's ruling based upon the statute of limitations? It is agreed that if his ruling was based upon the statute of limitations, then we win. The only issue is, was Judge Gayden's ruling based upon the statute of limitations? We all agree that if it was based upon the statute of limitations, we win. We all agree that the law is set out by the Tennessee Supreme Court in Parrish versus Marquis. We agree that a statute of limitations dismissal does not allow for a malicious prosecution action. So logically, let's look at Judge Gayden's order, which was considered by the trial court as the order in the underlying case, and it was agreed in the trial court and in the order that Judge Aubrey's consideration of Judge Gayden's order would not convert this motion to a summary judgment motion. That was stipulated and agreed. So, as we quoted in our brief and was quoted by opposing counsel in his brief, Judge Gayden said, and I quote, "Therefore, the motion for summary judgment filed on behalf of Horizon Trades DBA Best in Town is hereby, all caps, granted on the grounds that this action for damages to or conversion of personal property, excuse me, is thereby granted on the grounds that this action for damages to or conversion of personal property rather than for breach of contract. As such, Charmaine Stewart, the original plaintiff in the underlying action, is barred by the applicable 3-year statute of limitations. I don't see how it can be any clearer. That was the basis that the underlying action was disposed of.
What is the significance of the additional verbiage that the court used?
It's dictum. If in fact the order was appealed, I'm surmising that Judge Gaden was covering, in the event that the order was appealed, that he was given an alternative basis for why he would have dismissed the case if he was wrong that the statute of limitations had not expired, but it was not appealed. Therefore, the dismissal was based upon statute of limitations.
All right, thank you.
And I really don't have anything else to add. I wish I had more to say, but I tried to teach young lawyers a long time ago that if you don't have anything to say, don't take the chance of saying something.
Well, we'll let you reserve this 11 minutes for argument before a panel that did not include Judge Bennett, Judge McBrayer, or me. How about that? All right, unless there's some questions, we'll hear from Mr. Preston.
Well, Your Honor, thank you. I would just like to point out that after the language that Judge Gaden had in his order, he goes further and writes, further, although the court finds that there is no viable breach of contract claim, the statute of frauds would have required any contract between these parties to be in writing. There was no written contract in this case, even though the alleged contract involved goods valued at well over $500. And so, respectfully, Your Honor, I think the trial court should have considered the entire order, because you have multiple bases for the dismissal. And so, even though the court could have found simply based on the statute of limitations, the court went further and explained its ruling. So at the same time, we have an order that is based, and I respectfully submit that based on the cases I've seen, when they have been on, like the Paris case, the statute of limitations, then that's all that there are. They don't have alternative language in there about other findings. And so, yes, it's true that there was a finding based on the statute of limitations. However, at the same time, the court did find that there was no viable contract and that the statute of frauds applied as well. And so, actually, we submit that does satisfy that second prong of a malicious prosecution case, in that it was clear from Judge Gaden's order that this case was dismissed on the merits on those bases. It was based not only on procedural grounds, which is the intent in my understanding of the Paris case, but also on the substantive grounds, which is what I, in reading the malicious prosecution cases, believe the intent of each of those cases is, and that is, you don't have a case if a court only finds that there's a violation, that there's a dismissal based on a procedural technical ground. And that's not what we have here. In this case, is distinguishable based on this order that Judge Gaden entered.
All right, anything further, Mr. Preston?
No, Your Honor.
Very good, thank you. And Mr. Glassman, thank you as well. We will take your case under advisement. Mr. Hibner.
This honorable court is now adjourned.